Hello and welcome to another episode of the Elder Care Legal Digest. I am your host, Karen Hector. Today we are going to be discussing the differences between wills and trusts, and we're going to be looking at which of those might be right for your estate planning needs. So if that is something that you would like to know more about, do stick around while we delve deeper into this discussion. Now, just a word of caution before we begin. The information that we share on this channel is intended for educational purposes only. It is not legal advice and it does not relate to any specific person or case. Now, with that said, we can jump right into our main discussion. When it comes to estate planning, many persons are unsure whether they need a will or a trust, or perhaps both. These two legal tools often come up in conversations about estate planning, but their purposes and their benefits and their limitations can be quite confusing. At first glance, they might appear very similar. They both outline how your assets will be distributed after you're gone. However, they function in different ways and they're designed to meet specific needs. Choosing the right one really will depend on your personal situation, your goals, and the level of control that you would want to have over your estate. For this reason, understanding the difference between the wills and the trust is essential for making informed decisions that will align with your wishes and that will protect your loved ones. Let's explore what each of these has to offer, when to use them, and how they can work together. Now, we can start by looking at what a will is. A will is a legal document. It outlines your wishes for how your estates and your property should be distributed after your death. And it can also specify guardian for your minor children. And of course, it names an executor who is responsible for carrying out the terms of the will. The will is a pretty straightforward document, and it is often the first step in estate planning. However, a will must go through what we refer to as the probate process. Now, this is a court-supervised procedure to validate the document and to ensure that all debts and taxes are paid before the assets are distributed. While the probate can be time-consuming and public, it is a necessary step if the will is your primary estate planning tool. Now, what is a trust? A trust is a legal arrangement that allows you to transfer ownership of your assets to a trustee, and that trustee would manage the assets on behalf of the beneficiaries. Now, unlike a will, the trust can take effect during your lifetime or after your passing. That just depends on how it is structured. The trusts offer several advantages over the will, and those advantages include avoiding the probate process that I referred to earlier, and that of course saves time and it keeps your affairs private. It provides greater control over how and when your assets are distributed, and it does offer some tax benefits as well as, in certain circumstances, protection from creditors. Trusts are particularly useful for complex estates or for families with special needs dependents, or for anyone who really wants to maintain privacy and reduce the burden on their loved ones. So, when should you use a will or a trust? A will is a good choice if you have a straightforward estate, or if you want to name a guardian for your minor children, or if you're comfortable with your estate going through a probate process. It is also quite useful if you have specific items or assets that you want to distribute to particular persons. The will is really an essential component of any estate plan, even if you also have the trust. They operate like a kind of safety net to address assets or wishes that were not covered in your trust. The trust would be ideal in situations where you want to avoid the probate process and keep your estate private, or you have minor beneficiaries or special needs dependents who require ongoing support, or if you own property in multiple countries or states and would need to go through probate in each of those states, or if you want to have more control over how and when your beneficiaries receive their inheritance. Also ideal in those circumstances where you are concerned about estate taxes or protecting your assets from creditors. Trusts provide more flexibility and more options for customization, and that makes them quite a powerful tool when it comes to the complex situations. Now, one of the questions that we get asked from time to time is whether you should have both a will, whether you can have both a will and a trust. And of course, the answer to that is yes. And in many cases, it is recommended, because while the trusts are great for avoiding probate and managing assets with more control, the trust does not completely replace the need for a will. And so very often we have what we may refer to as a pour over will. That will would capture all of those assets that you did not include in your trust, and that happens sometimes inadvertently. But for anything that was not included in your trust, then having a will would ensure that nothing is left out of your estate plan, even if it is something that you acquire after you have passed, which is quite possible. So by combining both and using both the will and the trust, you are able to create a very comprehensive estate plan that addresses your immediate needs and provides long-term security for your loved ones. Now, there are persons who believe that the will is enough, and there are also others who believe that the trusts are only for the wealthy. No, neither of these two statements is correct. A will is important, but it has limitations, particularly when it comes to probate and privacy. Trusts, on the other hand, are not just reserved for millionaires. They're very practical tools for anyone who wants to have more control over their estate, whether that estate is modest or extensive. Another misconception is that setting up a trust is overly complicated. While the trust does require more initial effort, working with an experienced attorney can make the process much smoother, as well as ensure that everything is set up correctly. Deciding between a will and a trust, or both, depends on your unique situation and your goals. You can start by evaluating the complexity of your estate, looking at your priorities for your loved ones, and considering whether avoiding probate or maintaining privacy is something that is important to you. If you're not sure where to begin, then consulting an estate planning attorney can provide clarity, and it can help you to understand the benefits of each option and tailor a plan that meets your specific needs. Remember that the goal of estate planning is not just about distributing your assets. It's about protecting your legacy, reducing stress for your loved ones, and ensuring that your wishes are honored. Whether you choose a will or a trust or both, acting now can bring peace of mind for the future. Wills and trusts are both powerful tools that serve different purposes. By understanding how they work and what they offer, you can make choices that reflect your values and protect those that you care about most. Take the time to explore your options and create an estate plan that feels right for you. It is a decision that brings peace of mind, knowing that your legacy will be handled exactly the way you envision. That's all for today's video. Remember, if there are any questions that you would like us to cover in any of our future videos, simply drop them in the comments below and we will try to answer as many of your questions as we possibly can. We also invite you to like, share, and subscribe to our channel, and this will help to keep legal information free and accessible to all our seniors. We do thank you for spending your time with us today, and we'll see you again in one of our next videos.